Hello and good morning friends, welcome to CEC Ediset live lecture. Dear friends, as you know that in our previous sessions we talked about Indian judiciary, and I would like to tell you that it is the continuation with the previous lecture, or we could say that it is a series on the Indian judiciary. We discussed in previous lectures about the fundamental rights. Today basically we are going to study or discuss about the hierarchical system in the Indian judiciary, and specifically we are going to discuss about the appointment, removal as well as transfers of judges of the Supreme Court and High Court. For this we have again with us in our studios Dr. Rakesh Kumar. He is a assistant professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. I hope that this lecture is going to be one of the productive lectures when we talk especially about the law in India. So first of all, I would like to welcome our guest Dr. Rakesh Kumar. So welcome to the Ediset lecture, as it is a series and we have discussed a lot about the Indian judiciary earlier, but still before continuing further, I would like you to throw some light on Indian judiciary, that is the basic concept, and then we move forward towards the appointment, removal and the transfers of the judges, especially of the Supreme Court and High Court.
Good morning listeners. In my previous series of lecture on the Indian constitutions, I have given you detailed analysis regarding the various provisions of the fundamental right, along with the way it has been interpreted by the Indian judiciary. In today's we will continue with the provisions of the Indian constitutions along with the system of the Indian judiciary. And in this series we have divided our lecture in 3 parts. In first part I will give you the brief idea about the kind of the hierarchy which has been set up by the Indian judicial systems, and then we will go to the detailed analysis regarding the various provisions of the Supreme Court of India regarding the appointment of judges of the Supreme Court, the provisions regarding the removal of the judges of the Supreme Court, and along with that we will also take up the jurisdictions of the various jurisdictions of the Supreme Court which has been conferred by the Article 131 onwards of the Indian constitutions. And subsequent to that we will go to the different provisions regarding the constitution's powers and positions of the High Court, as well as the jurisdictions which has been conferred upon the High Court by the Indian constitutions. As far if you recall my first lecture, where I have given you that the Indian constitution has provided for the 3 different organs of the government. The first, you have the legislatures, whose prime business is to make a law, amend the law, as well as to repeal the law. Then you have the executives, who has been entrusted with the responsibility of the implementing the provisions of law which has been made by the parliament. And then you have the judiciary, which has provided which has been given the responsibility to give the final interpretations to the provisions of the law which may be enacted by the parliament. So apart from the setting of the 3 different organs of the government, Indian constitution has also provided for the setting of the federal form of the government. Under the federal form of the government, we are having the 2 different set of the governments. One is operating at the central levels, and other from the government is operating at the state level. So as far the relationship between the central government and state level is concerned, definitely in the working of the complex mechanism of the federal scheme, some kind of conflict might arise in the working of the constitutional provisions, because the federal constitution essentially depends upon the basic premises of the division of power between the 3 different organs of the government. So as far the union government is concerned, here all 3 organs of the government are equally applicable with respect to the union government in the form of the parliament, then the union executives, as well as the union judiciary. And similar kind of structure you can also find under the state system, where they are having the state legislatures, then the state executives, as well as the state judiciary. But if you see the major departure from the basic scheme of the federal constitution that instead of providing the dual form of the judiciary, we have decided to provide a one integrated form of the judiciary, which will take care of all the law which may be enacted by the Union Parliament as well as the state legislatures, starting from the union government level to the state government level. So we have not adopted the US system where they are having the separate Supreme Court at the state level. What we are having the integrated and unified system of the judiciary, where the Supreme Court is at the apex, Supreme Court is at the top of the Indian judicial system. Then we are having the different high court in the each state. Of course, we have some of the state we are having the common high court, and then we are also having the system of the subordinate judiciary under the detailed provisions of Article 233 to 237 of the constitutions. As far the subordinate judiciary is concerned, definitely the subordinate judiciary is working under the direct supervisions and control of the High Court. So first I am coming to the kind of hierarchy which has been provided by the Indian judicial systems. First, if you see the Indian judicial system, then at the top you are having the Supreme Court of India. So the Supreme Court of India is concerned, it is the apex court of India, and it is the final interpreters of the provisions of the constitution. And as far the positions of the Supreme Court is concerned, the Supreme Court is also known as the protectors as well as the guardians of the provisions of the constitution. So when you are talking about the protectors of the provisions of the constitutions, then it means here the Supreme Court has been given the direct responsibility of ensuring the various form of the fundamental right which has been given to citizens by the part 3 of the constitutions. And if you see the beauty of the Indian constitution, that under Article 32 of the constitution, the right to approach the court for the enforcement of fundamental right itself has been accorded the status of fundamental right, and any persons whose fundamental right has been infringed by any of the activity of the instrumental state, then that case they can directly approach to the Supreme Court for the enforcement of fundamental right under Article 32 of the constitutions. And apart from this, you also have the provisions like Article 13 clause 1 and Article 13 clause 2 of the constitutions. And if you see the provisions, particularly the Article 13 clause 2 of the constitutions, here it has imposed absolute embargo on the power of parliament to make a law which are in direct contradictions with the provisions of fundamental right. So here the Supreme Court has somehow assumed the responsibility of the judicial review in a view of the protecting the very preserves and the basic features of the Indian constitutions. So here the Supreme Court itself has assumed the responsibility of the guardians as well the protectors of the provisions of the constitutions, and under these provisions here the Supreme Court has final words with respect to the any law which has been enacted, and definitely if any law has been enacted by the parliament, then such law will now be subject to the other extended doctrine which has been preponderated by the Supreme Court in Keshav Bharati case under the name of the doctrine of basic structures or doctrine of basic features. So as far the Supreme Court is concerned, apart from being the protectors and the guardians of the provision of the constitutions, here the Supreme Court of India has been given the very wide variety of jurisdictions under the provisions of the constitutions. And if you see the kind of the jurisdiction which has been accorded or conferred on the Supreme Court, here the Supreme Court is the final court of appeal in all the civil, criminals and other matters, and thus in this process by way of judicial interpretations, here the Supreme Court is somehow ensuring the uniformity of law throughout the territory of India. So here the Supreme Court which are giving the final interpretation, so no one will have any kind of ambiguity regarding the nature and scope of the law which may be enacted by the parliament as well as the state legislatures. And apart from the kind of jurisdiction which has been conferred to the Supreme Court, here the Supreme Court is also the ultimate repository of the all judicial power at the national level by virtue of being a summit court, as well as it is the upholders and final interpreters of the provisions of the constitutions, and it is also a defenders of the fundamentals provisions of the rule of law. So this kind of unique provisions you can find only under the Indian constitutional setup, where the Supreme Court has been accorded this kind of the unique provisions under the Indian constitutional setup. Now I am coming to the provisions regarding the High Court. As far the High Court is concerned, here the High Court of India is the supreme judicial authority at the state level. So, the High Court of the state is having the both originals as well as the appellate jurisdictions. Here the original jurisdictions is also having their genesis under the writ power of the which has been given to the first the Calcutta High Court, and after the adoption of the constitutions, here the writ jurisdictions of the High Court has been extended to all the high courts. So, here it has been given both the original jurisdictions as well as the appellate jurisdictions. So, the original jurisdiction in the form of the writ power which was enjoyed by the High Court is somehow being preserved after the adoptions of the Indian constitutions. And as far the appellate jurisdictions of the High Court is concerned, here the High Court has been given power to exercise the appellate jurisdictions with respect to the any kind of decisions which may be given at the district level as well as the session level. So, as far the constitutions of High Court is concerned, here the Indian constitution has provided for the setting of High Court for each of the state except we have the exception in the form of the Manipur, Meghalaya, Tripura and Nagaland, which are having the common High Court of Assam at its seat in the Guwahati, and we also have the common High Court for the High Court of Chandigarh for the state of Punjab as well as for Haryana, and we also have the common High Court for as a Mumbai High Court for the which is common for the Maharashtra as well as the Goa. So, as far the power of the High Court is concerned, particularly the Article 226 of the Constitution is concerned, here it has been given the power to issue writ not only for the protections of the fundamental right of the citizens, but here the High Court has been also been given power to issue writ for any other purpose. So, scope of the writ jurisdictions of the High Court under Article 226 and the Supreme Court under Article 32 is concerned, here the kind of power which has been accorded to the High Court is much wider than the power which is being enjoyed by the Supreme Court under Article 32 of the Constitution. And as far the power of the High Court to issue writ is concerned, here the writ can be issued not only against the state statutory authority, but it can also be issued against any persons or body performing the public duty. So, this kind of the power has been conferred to the High Court, and the detailed aspect of the High Court provisions I will take up when after finishing the various provisions regarding the Supreme Court. Now, I am coming to the subordinate court. As far as the subordinate court is concerned, at the district level we are having the district court which is being headed by the district judge, who is the highest judicial authority, and he is having the power to take up both the civil matter as well as the criminal matter at the district levels. So, as far as the power of the district judge is concerned, he hear the appeal from the decision of the superior magistrate and also try more serious criminal cases which is known as the session cases, or which is being handled by the session court. And if you see the kind of the change which has been introduced by the CRPC in 1973, where the trial of the criminal cases is being done exclusively by the judicial magistrate, and the chief judicial magistrate is the head of the criminal court within the district. Apart from the criminal court which are having the district, we also had the system of the metropolitan magistrate, and here the system of metropolitan magistrate is being provided in the metropolitan areas. So, the judicial and metropolitan magistrate discharging their judicial functions under the direct administrative control of the respective state high court. So, and apart from the district court, in the bottom of the judicial system we are having the system of the civil court, along with them we have the municipal court and the subordinate judges. So, these kind of structure is somehow providing the very base to the foundations of the Indian judicial system, and it is the kind of role which are being performed by the lower court at the district levels, because all the cases is invariably start from that levels, and afterwards it move by way of appeal to the high court, and then subsequent to the Supreme Court if the party is not satisfied with the kind of decision which was given by the lower courts. So, after giving the brief idea about the kind of hierarchy which has been set up by the Indian judicial system, now I am coming to the provisions regarding the Supreme Court. So, as far the Supreme Court of India is concerned, here it is the apex court, and it as I said, that it is the final interpreters of the constitutions as well as the law which may be enacted by the parliament as well as the state legislatures. So, as far the power of parliament is concerned, here the parliament is having the power to make a law regulating the compositions, jurisdictions and the power of the Supreme Court. So, here though Constitution has originally provided for the setting of the Supreme Court along with the kind of jurisdiction which has been given, but at the same time Parliament has been given power to further go for the restructuring as per the demands of the society as well the change of the change of the times. So, as far the Constitution of the Supreme Court is concerned, you can simply see the provisions of Article 124 clause 1 of the Constitution. It provides that there shall be a Supreme Court of India consisting of a Chief Justice of India, and until Parliament by law prescribe a larger number of not more than 7 other judges. So, originally when the constitutions came into being, it provided for the 7 other judges as well the Chief Justice of India, and the Supreme Court has functions with this strength since 1950 to 1956. In 1956, the Parliament had decided to increase the number of judges, and in this process the total number of other judges has been increased to 9. Then again in 1960 this provision was being amended, and the number of other judges which has been given the responsibility of performing the duty in the Supreme Court has been increased to 13. Then again in 1977 the number of other judges has been increased to the 17, and in 1986 the number of other judges has been increased to the 25. So, finally in 2008 here the Parliament has again decided to increase the strength of the Indian Supreme Court by increasing the number of judges by appointing the 13 other judges. So, at present the Supreme Court is manned by the Chief Justice of India and 13 other judges, and definitely the Parliament will have the sole prerogative to decide about the number of judges depending upon the kind of work which has been assigned to the Supreme Court and the kind of the pending cases. If the existing strength is not sufficient, in that case Parliament will be compelled to have a look regarding the strength of the Supreme Court, and Parliament may accordingly decide about the increasing the strength of the Supreme Court. After the giving you the idea about the strength of the Supreme Court, now I am coming to the most contentious issue which has raised the eyebrows in view of the various constitutional experts as well as the political commentators regarding the existing provisions of the appointment of judges of the Supreme Court as well as the judges of the High Court. So, as far the if you see the constitutional provisions regarding the appointment of judges concerns, here the Article 124 clause 2 of the Indian Constitutions provide the details procedures which has to be followed regarding the appointment of judges of the Supreme Court, and you can find the similar kind of provisions under Article 217 clause 1 of the Indian Constitutions regarding the appointment of judges of the High Court. So, as far the provisions of Article 124 clause 2 is concerned, is said that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultations with such of the judges of the Supreme Court and of the High Court in the state as the President may deem necessary for the purpose, and shall hold the office until he attain the age of 65 years. And this provisions is subject to the proviso, and what is being provided by the proviso to Article 124 clause 2 is said that in case of the appointment of judge other than the Chief Justice, the Chief Justice of India shall always be consulted. So, here you have the basic format regarding the how the judge of the Supreme Court has to be appointed, but you have to keep your focus on the starting line of the Article 124 clause 2 of the Constitutions. Here say every judge of the Supreme Court. Here, so every judge of the Supreme Court does not mean only the other judges of the Supreme Court, but it will also include the Chief Justice of India. And the other crucial word which has been provided by Article 124 clause 2 of the Constitution, that in process of the appointment of the judge of the Supreme Court, here the President is required to follow the procedure which has been prescribed by the Article 124 clause 2 itself, that is the consultations, that is the after consultation with such of the judges of the Supreme Court and High Court in the state as the President may deems necessary. So, it means here as far the appointment judges concerns, here it is not depends purely on the prerogative of the executives, but here the executive is also required to consult with the requisite number of judges regarding the appointment of judges, because when the constitution was being framed, then at that point of time this article was subject to the very intense debate in the parliament. And here the members of the Constituent Assembly was not in the view to leave the entire process of appointment of judges in the hands of the judiciary, because here the questions of accountability will come. And when this issue was raised in the Constituent Assembly as to the judges will be accountable to whom, and if you see the kind of interpretation which has been given to the these provisions, here under the current system the judges are accountable to none. If they are accountable to anybody, then definitely they are accountable only to their own consciousness. So, as far the accountability of judges concerns, so what the system which has been devised by the constitution maker is that here the power of appointment will remain in the hands of the executives, but the executive is required to follow the bill define the constitutional process. So, here as far the executive is concerned, they will not act as the sole arbitrators regarding the appointment of judges, they will merely act as a check regarding the appointment of judge of the Supreme Court and High Court is concerned. So, as far the appointment concerns, definitely they will be appointed by the executives, and under the parliamentary form the government, executive is responsible to the parliament. So, and the members of the parliament are ultimately responsible to the people of this country. So, here the constitutions maker has tried to introduce the indirect accountability on the part of the every judges who has been appointed the judge of the Supreme Court or the High Court. So, similarly, you can also find the same kind of provisions under Article 217 clause 1 of the Constitution, which says that every judge of the High Court shall be appointed by the President by warrant under his hand and seal after consultation with the Chief Justice of India and the Governor of the State, and in case of the appointment of judge other than the Chief Justice, the Chief Justice of the High Court, and shall hold office in case of an additional or acting judge as provided in Article 224, and in any other case until he attain the age of 62 years, provided further that in case of the appointment if any such person has been appointed, then he will continue in office till the age of 62 years. So, as far the appointment of judges is concerned, the one very healthy constitutional convention has developed in this country, and the senior most judge of the Supreme Court is invariably being elevated to the post of Chief Justice of India, and this convention has almost acquired the status of law, because constantly is being followed since 1950 to 1977, but this practice was suddenly been broken in 1977 when the senior most when the 1973 when the Justice A.N. Ray was being appointed the Chief Justice of India by superseding the three other senior judges of the Supreme Court, that is the Justice Hegde, Justice Grover and Justice Selhut, and immediately this appointment was made in protest. All the three judges had resigned from the Supreme Court, and this issue has created a lot of controversy among the constitutional expert, and it is being widely anticipated that this appointment is being made purely on the political considerations, because here this appointment was being made immediately after the emergency. And again this convention was being broken in 1977 when Justice M.U. Beg was being appointed as Chief Justice of India, superseding Justice H.R. Khanna. And as far the superseding Justice H.R. Khanna is concerned, here this issue was also being challenged through the writ jurisdictions in the Delhi High Court, but the Delhi High Court has given the altogether very flimsy kind of interpretation by saying that since Justice Khanna has already resigned from the Supreme Court, so after his resignation it is the Justice Beg who is the senior most, so his elevations to the post of Chief Justice of India is not suffering from any kind of impropriety. So, as far the provisions regarding the breaking of the convention is concerned, here the government has tried to justify these conventions purely on the basis that they have purely relied upon the recommendations which was given by the law commissions in its 14th report way back in 1956. And if you see the kind of recommendation which was given by the Law Commission way back in 1956, what the Law Commission has suggested, that in case of the appointment of Chief Justice of India, the seniority should not be only rules. So apart from the seniority, some of the other factors which has to be taken into considerations by the executives regarding the appointment of the Chief Justice of India is concerns, definitely has the executives will give a close look towards the ability and experience of the judge to hold the positions of the Chief Justice of India, and executive will also examine their the competencies to handle the complex administrative matters. So here what the Chief Justice of what the Law Commission has suggested, that if the person is going to be appointed Chief Justice of India, definitely seniority should not be the only rule. It means apart from the seniority, some of the other factors regarding the ability, here the administrative competency, these things has to be taken into considerations. But the executive has tried to justify simply by saying that here the seniority should not be considered the only rule regarding the appointment of the judges, and whatever the consideration which has been taken by the executives regarding the appointment, it is based on their ability and experience as well as the administrative acumen. And because the role of the Chief Justice of India in the contingent times will become very important, because he has been given the responsibility as a protectors and the guardians of the constitutions. And here the Supreme Court in the exercise of the visions has somehow tried to check the indiscriminate amendment which is sought to be introduced by the Parliament by introducing the doctrine of basic structures. In fact, this basic structure doctrine is also being criticized by saying that this kind of limitation is not being provided by the constitutions, and the judiciary of any country cannot dictate as to what kind of the law has to be enacted and how the existing constitutional provision has to be modified. But the Supreme Court has tried to say that since the future the Parliament is being elected on the basis of party line, and it might be possible that some of the cases the government may not be in positions to introduce their ideological visions because the certain provisional constitutions which may act as obstacles. So what they can do is that they will simply try to change those provisions, and they will so once those provisions will be deleted from the constitutions, so they will have the free hand to introduce any kind of measures which will suit their political and the other ideologies. So what the Supreme Court has essentially tried to set by the introducing doctrine of basic structure is that here the power of amendment has been given. So amendment itself implies that the old constitutions must survive despite it has been subject to some kind of change. So if the government is not at all happy with the existing constitutional provisions, and if they want that the existing constitution is to be replaced by some other constitutions, then the Parliament is not having any kind of provisions, and Parliament can definitely constitute a new Constituent Assembly, and the new Constituent Assembly may be given mandate to frame the new Constitution of India. So here by way of amendment, here the Parliament cannot altogether replace the existing provisions by the altogether new provisions. That's why the judiciary has introduced the limitations on the power of Parliament to check the provisional constitutions by introducing the doctrine of basic structures. So as far the interpretations to the provisions of Article 124 Clause 2 is concerned, here this issue has first invited the attention of the Supreme Court in the Union of India versus Sakal Chand Seth case way back in year 1977, and in this case the Supreme Court was having the occasions to examine the meaning of the word consultations which has been used under Article 124 Clause 2 of the Constitutions. And the Supreme Court said that the word consultations simply means the full and effective consultations. So for the full and effective consultation, what is necessary that all the three constitutional functionary must have for its considerations full and identical facts, and on the basis of which they would be able to take a decisions regarding the appointment of any persons as a judge of the Supreme Court or the High Court. So as far the power of executive is concerned, in Sakal Chand case the Supreme Court has expressed the view that President has a right to differ from the differ from the decisions which has been suggested by the Chief Justice of India after going through the consultation, because the kind of interpretation which was given by the Supreme Court in Sakal Chand case, here the Supreme Court says that the constitution maker had used the word consultations. So, as far the consultation is concerned, here the word consultations cannot be interpreted as means concurrence. So, here they are required to consult with the requisite number of judges, but does not mean that they have to concur. So, here the President is not bound by the opinions or view which was being suggested by the Chief Justice of India regarding the appointment of judges. So, after the Sakal Chand case, when the Supreme Court has merely interpreted the meaning of the word consultations, this issue was taken details by the Supreme Court. In other famous case, that is the SP Gupta versus Union of India, and this case was decided in year 1982, and this case is also being known as the judges transfer case or the first judges transfer case. So, as far as the word consultation is concerned, definitely in this case also the Supreme Court has concurred with the explanations of the word consultation which was given by the Supreme Court in Sakal Chand case, but in this case the Supreme Court has laid down the details provisions which has to be followed regarding the appointment of judges of the Supreme Court. As far as the SP Gupta case is concerned, here this case is pertains regarding the power of executives to extend the tenures of the additional judge of Delhi High Court, Justice Kumar. So, what happened in this case is that there was allegations of bribery against Justice Kumar, and the Chief Justice of Delhi High Court has suggested for not extending the tenures. But the same time the Chief Justice of India has expressed the view regarding the extending of the tenures of Justice Kumar by saying that the allegations of bribery is not being completely proved. So, in this case what happened is that the President of India, instead of relying upon the view of the Chief Justice of India, they have purely relied upon the view which was expressed by the Chief Justice of Delhi High Court in non extending the tenures of the Justice Kumar of the Delhi High Court. So, the main issue which the Supreme Court has to decide as to what are the status of the view which was being expressed by the Chief Justice of India, whether the Chief Justice of India enjoy any kind of primacy over the view which may be expressed by the other judges of the judges who may constitute the collegium system or who will be the part of such consultation process. So, as far the view of the positions of the Chief Justice of India is concerned, here in SP Gupta case the Supreme Court said that the opinion of Chief Justice of India had no primacy over the opinion of the Chief Justice of High Court under Article 217 of the Constitution, and Justice Bhagwati, who was speaking on behalf of the majority, has pointed out that all the three functionary of the Constitution, that is the Chief Justice of High Court, Chief Justice of India and the Governor of the state, are given the equal importance in the consultation process, and there is no superiority over the opinion of one over that of the others. So, this was the view which was given by Justice Bhagwati, and they have accorded the equal importance to the view which was being expressed by the Chief Justice of India, Governor and the Chief Justice of High Court. However, this case is also significant because in this case the Supreme Court has also suggested for the establishment of judicial commissions to make a recommendations to the President regarding the appointment of judges of the Supreme Court and High Court. But as far the power of the executive is concerned, here in SP Gupta case the Supreme Court has categorically stated that the only ground on which the decision of the government can be challenged is that it is based on the mala-fide and irrelevant considerations, and in which all the constitutional functionary has expressed their view regarding against the appointment of such persons as judge of the High Court. So, as far the positions of the Chief Justice of India is concerned, here this case has clearly established that Chief Justice of India do not enjoy any kind of supremacy or primacy over the other judges of the this collegium systems. But as far the minority view is concerned, the minority view was being synthesized by the Justice Pathak and Tuljapurkars, and they said the advice of the Chief Justice of India should be given the more weightage over the advice of the Chief Justice of High Court, but it would not operate as a veto. And as far the Justice Gupta is concerned, he said the advice of the Chief Justice is binding on the President. So, the kind of interpretation which was given by the Supreme Court regarding the appointment and transfer of judges in SP Gupta is concerned, here this issue was also again taken by the Supreme Court in Subhash Sharma versus Union of India in 1991. And Subhash Sharma case, here the Supreme Court has expressed the view that this issue needs to be referred to the larger bench to provide the clarity regarding what the procedures which the executive has to follow regarding the appointment as well as the transfer of judges of the Supreme Court and High Court. And this issue was being considered in details by the Supreme Court in Supreme Court Advocate on Record Association versus Union of India in year 1994, and this case the Supreme Court by majority of 7:2 has laid down the detailed guidelines which will govern the entire process of appointment as well as the transfer of judges. As far if you see the ratio of the Supreme Court Advocate on Record case, here the Supreme Court has laid down the significant guidelines, and the most important guidelines was that the greater significance should be attached to the view of the Chief Justice of India form after taking into account the views of the two senior most judges of the Supreme Court. So, as far the appointment of judges concerns, here the Chief Justice of India is required to consult with the two senior most judges of the Supreme Court. And as far the consultation process is concerned, here the Supreme Court in this case has stated that all the constitutional functionary must act collectively in the judicial appointment system, and the selection should be made as a result of the participatory consultative process in which the executive should have the power to act as a mere check on the exercise of power by the Chief Justice of India. As far the transfer of judges of the High Court is concerned, here the Supreme Court said that the Chief Justice of India has final say in the transfer of Chief Justice and other judges of the High Court, and the transfer of Chief Justice and the judge of the High Court cannot be challenged in any court. As far the appointment of Chief Justice of India is concerned, here in this case the Supreme Court expressed the view that the appointment of Chief Justice of India has to be by seniority. And as far this provision is concerned, here said no judges can be appointed by the Union government without consulting the Chief Justice of India. So, as far the fixation of strength of the Supreme Court or as far as the High Court is concerned, the fixation of strength of the High Court is a justiciable issue. So, as far the next question regarding as to who has to initiate the process of appointment and transfer is concerned, here in this case the Supreme Court has clarified that as far the initiations of the proposal for the appointment in case of the Supreme Court must be by the Chief Justice of India, and in case of the High Court it has to be by the Chief Justice of High Court. And as far the transfer of judges or the Chief Justice of High Court is concerned, here such proposal must be initiated by the Chief Justice of India only. So, as far the kind of after the participatory consultative process, if any kind of recommendations has been given by this collegium system, and if that collegium system that view or opinion is not being acceptable to the government, then that case here the government is required to record a reason as to why the kind of the suggestion which was given is not being accepted, and what are the factors which has been taken by the executive into considerations before making this kind of recommendations. So, whatever the view which has been considered by the executives, it has to be again forwarded to Chief Justice of India, and then it has to be placed before the collegium system, and then the collegium system will have the power to again review as to whether they will reiterate with the opinion, reiterate with the view which they have suggested, or they will withdraw the suggestions which they have made. So, once they have decided to reiterate with the opinions, then that case the President will not have any kind of options, and they have to go through that appointment process. But if they have decided to withdraw, then definitely in that case it is the view which was adopted by the executives that will have the primacy. So, and the Supreme Court advocate on record case is also important, because in this case the Supreme Court has again clarified that as far the appointment of judges as well the transfer of judges concerns, here the political interference in such appointment process must have to be minimal. So, these are the some of the significant guidelines which has been given by the Supreme Court regarding the appointment of as well as the transfer of judge of the High Court is concerned. So, once the Supreme Court advocate on record, the Supreme Court has given detailed guidelines, then again some doubt has been raised regarding that the number of the persons to whom the Chief Justice of India is required to consult, and how this process has to be followed in the true spirit of the provision of the Constitution. So, the President had decided to refer this matter to the Supreme Court for the advisory opinion, and when this the argument was going on, that point of time Attorney General of India has given the assurance to the Supreme Court that whatever the advice that will be given by the Supreme Court, it will be binding on the government, it will be implemented by the government. So, the Supreme Court has again given the new look regarding the entire procedures of the appointment as well as the transfer of judge of the Supreme Court, and for this purpose a 9-judge bench of the Supreme Court was being constituted, and they have made a detailed recommendations regarding the procedure which has to be followed regarding the appointment as well as the transfer of judge of the Supreme Court and High Court. So, as far the first thing regarding the consultations process is concerned, here the Supreme Court has clarified that as far the consultations process which has been used under Article 124 clause 2 as well as under Article 217 clause 1 of the Constitution concerns, here the consultation process which has to be adopted by the Chief Justice of India required the consultations of the plurality of the judges in the formations of the opinion of the Chief Justice of India. So, the sole individual's opinion of the Chief Justice of India does not constitute consultations in the meaning of Article 217 clause 1 as well as Article 222 clause 1 of the Constitution. The second important things which was said by the Supreme Court in the presidential reference case is that the recommendations of the collegium should be based on the consensus, and unless the opinion is in the conformity with that of the Chief Justice of India, no recommendation to be made to the President. So, as far the view of the judges who have been consulted by this collegium system is concerned, here with respect to this the Supreme Court has clarified that the view of the other judges consulted should be in writing and should be conveyed to the Government of India by the Chief Justice of India along with the Chief Justice of India's view to the extent set out in the body of such opinions. So, as far the appointment of judges of the Supreme Court is concerned, in the presidential reference case, the Supreme Court has widened the scope of the consultations by saying that under Article 124 clause 2 of the Constitution, the Chief Justice of India is required to consult a collegium of the 4 senior most judge of the Supreme Court, and if the 2 judges give the adverse opinion, then such cases the Chief Justice should not recommend the name of such persons to be appointed as a Chief Justice of India. So, if you compare the Indian presidential reference case with the Supreme Court advocate on record case, here earlier they were required to merely consult with the 2 senior most judges of the Supreme Court. So, but in Indian presidential reference case, here the scope of consultation is being widened. Now, the Chief Justice of India is required to consult with the 4 senior most judges of the Supreme Court regarding the appointment of judge of the Supreme Court is concerned. And apart from this, here the as far the who will constitute the collegium is concerned, here what the Supreme Court suggested that this collegium must include the successor Chief Justice of India. And apart from this, here what the Supreme Court has further stress on in this case is that as far the appointment of the Supreme Court is concerned, apart from this collegium of the 4 judges, here the Chief Justice of India is also required to consult other senior judge of the High Court if he belongs to that particular state from where a judge has to be appointed as a judge of the Supreme Court. And whatever the view which has been expressed by such a senior judge, it has to be recorded in writing, and everything has to be sent to the government through the memorandum, which will be forwarded by the Chief Justice of India. As far the appointment judge of the High Court is concerned, here the Supreme Court in the presidential reference case has clarified that the recommendation must be made in consultation with the collegium consisting of Chief Justice of India and the two senior most judges of the Supreme Court. So, apart from the Chief Justice of India and the two senior most judges of the Supreme Court, regarding the appointment of judge of the High Court is concerned, here the Chief Justice of India is also required to consult the sitting Chief Justice of that particular High Court, and if the person is to be transferred from some other High Court as a Chief Justice of that High Court, then Chief Justice of that High Court is also to be consulted along with the Governor. So, in this process the entire the scope of the consultation process is being considerably being widened by the Supreme Court in the presidential reference case. As far the transfer of judge of the High Court is concerned, this is the very contentious issue, because the kind of the some of the recent transfer which has been made by transferring the judge from the one High Court to other High Court is concerned, a lot of the question mark is being raised as by the bar councils as well as the other constitutional experts as well as in the academic circles. So, as far the transfer of High Court judges concerns, in this regard, in the presidential reference case, the Supreme Court has already clarified that in regard to transfer of the High Court judges, in addition to the collegium of the four judges, the Chief Justice of India is also required to consult the Chief Justice of two High Court, that is from being transferred and from being received. So, what is being essentially provided by this system is that here the Chief Justice of India is required to consult from this requisite number of persons, and after consulting and after ascertaining their views, they are required to place those views before the collegium consisting of Chief Justice of India and the four senior most judge, and after the detailed considerations, here the view which was being expressed by the collegium, it has to be forwarded to the president for the appointment for the transfer of judges from the one High Court to the other High Court. As far the justifications regarding the departure from the seniority or merit principle is concerned, here the Supreme Court has clarified that the very strong and cognizant reason have to be recorded as justifications for departure from the order of seniority among the High Court judges, and in respect of such senior judge who has been passed over or who is not being considered for such appointment to the High Court. As far the government refusal is concerned, here what the Supreme Court said that the Chief Justice of India is not entitled to act solely on his individual capacity without consultation with the other judges of the Supreme Court in respect of the materials and informations conveyed by the Government of India for the non-appointment of judges recommended for the appointment. So, as far the government refusal concerns, here if the collegium system wanted to depart from then that case, here the reason has to be recorded as to why they have decided to not consider or not to consider the view which was being expressed by these collegium systems. Apart from this, in the presidential reference case, the Supreme Court has also considered the scope of the judicial review regarding the transfer of the judge of the High Court is concerned. Here says the judicial, as far the scope of judicial review is concerned, it is relevant only to the extent that the recommendations made by the Chief Justice of India in this behalf, if it is not without consultations, then that case it will be not be binding, and that case it will be subject to the judicial review. So, what essentially is being provided that the entire constitutional process which has been prescribed regarding the appointment of judges, that has to be followed by the executives in words as well as the spirits. Apart from this, now I am coming to the kind of qualification which has been prescribed for the persons to be appointed the judge of the Supreme Court and High Court is concerned. As far as the Supreme Court is concerned, under Article 124 Clause 3 of the Constitution, here what is prescribed, the person shall not be qualified for the appointment as judge of the Supreme Court unless he is a citizen of India and he has been at least a 5-year a judge of the High Court or of the two or more such High Court in successions, or he has been for at least 10 years as an advocate of the High Court or of the 2 or more such High Court in successions. And apart from this, what is further been prescribed, which was never being considered by the executive regarding the appointment, that in the opinion of the president, he is a distinguished jurist. This is the one of the provisions, because we have produced so many sincere judges, and the judges with the integrity, who have reflected their complete devotions toward the cause of law, but still the judiciary has or the executive has not so far considered to accord this kind of the positions to the any other distinguished jurist. So these are the provisions, and this as far this provision concerns, it has become because recently the Lok Sabha has already passed the constitutional 121st amendment bill regarding the constitutions of National Judicial Appointment Commissions for the appointment of judges. And after the passing of this, because this is something which is having direct bearing with respect to the working of the federal scheme of the constitutions, and it is also being postulated by the proviso to Article 368 clause 2 of the constitution, that if any provision of the constitutions particularly concerned with the jurisdictions of the Supreme Court or High Court is concerned, and if any of the provision has to be changed or amended, then that case such bill has to be forwarded to the respective state, and the consent of not less than half of the state legislature has to be acquired. So after passing of the bill by the Lok Sabha, this bill is already being forwarded to the respective state. Now the view of the respective state is being awaited. Once the respective state will express their consent regarding this kind of amendment, then the National Judicial Appointment Commissions will be reality. And what is being suggested by the or anticipated by some of the constitutional experts, that here the kind of the demerits which has been creep in the system regarding the appointment judges concerns, it will be taken care by the National Judicial Appointment Commissions. And here but the one thing which has created a lot of controversy regarding the compositions of the National Judicial Appointment Commission concerns, because apart from the judge of the Supreme Court, one of the significant member, the law minister is one of the members, and the 2 other members has to be introduced in the National Judicial Appointment Commissions on the advice of the Prime Minister as well the leader of opposition in Lok Sabha and Rajya Sabha. Because what is being apprehended, that if this kind of system will be followed, then it may possible that all the future appointment to the Supreme Court and High Court may be considered on the basis of the political considerations rather than on merit. But we cannot simply jump on the conclusion before seeing as to in what forms and shape this National Judicial Appointment Commission finally acquired and how it works. And if you start work, because some of the constitutional expert has also expressed the view that the existing collegium systems should also be given a long rope, and we have to see and we have tried to analyze. But as far the existing malice in the judicial system is concerned, here this issue has invited the attentions of so many constitutional experts as well the Chief Justice, the former Chief Justice of India. In the Justice Burma has suggested that if we do not go for the self regulations and the self regulating code is not being established, then definitely in that case the parliament will enact a law and some other persons will be empowered to regulate the appointment procedures. And this issue has also drawn the attentions of the Constitutional Review Committee, which was constituted by the Vajpayee government under the Justice Venkat Chalaiya, and that committee has also suggested regarding the existing allegations of the corruptions in the judicial system and the kind of the factors which are being taken to consideration regarding the appointment judge of the High Court and Supreme Court is concerned. Because what is being alleged is that some of the appointment is being made purely on the basis of the caste line or some other narrow consideration in the total negations of what is being mandated by the various provisions of the constitutions. So apart from this, now I am coming to the kind of the safeguard which has been provided to the Indian judiciary under the various other provisions of the constitutions. Now I am taking the Article 125 of the constitutions, and it deals with the salary of the judge of the Supreme Court. So as far this provision is concerned, it says that there shall be paid to the judge of the Supreme Court such salary as may be determined by the Parliament by law, and until provision that behalf is so made, such salary as specified in the second schedule of the Constitution. And clause 2 to article 125 further provides that every judge shall be entitled to such privilege and allowance and to such a right in respect of the leave of absence and pensions as may be from time to time be determined by or under the law made by the Parliament, and until so determined to such privilege, allowance and right as specified in the second schedule of the Constitution. And this provision is also subject to the proviso which say neither the privilege nor the allowance of a judge nor his right in respect of the leave of absence or pension shall be varied to his disadvantage after his appointment. So, as far the salary of the judges is concerned, definitely Parliament has been given power to decide regarding the quantum of salary which will be paid to the judge of the Supreme Court as well the Chief Justice of India is concerned. But one of the important thing is that here the salary of the judges are not subject to it is not subject to vote by the Parliament, and it is being drawn directly from the Consolidated Fund of India. So, as far the current salary of the Chief Justice of India is concerned, after 2009, when it has been given effect from the year 2006, the salary of the Chief Justice of India has been raised to the 1,10,000 per month, and the other judges has been raised to the 1 lakhs. On the same fashion, the Chief Justice of the High Court is entitled to receive salary of rupees 1 lakhs per month, and the other judge of the High Court is entitled to receive the salary of rupees 19,000 per month. So, as far the provision is concerned, here it cannot be varied to his disadvantage after his appointment. So, this is the one of the provision which has been intended to ensure the independence on the part of judiciary. So, they will not have to look towards the Parliament for the increase of the salary and other kind of the privilege which is being enjoyed by the judge of the Supreme Court as well the High Court. But as far this provision is concerned, definitely it is not an absolute provisions, and it is subject to the restrictions which may be imposed under the extreme condition like the financial emergency. If you see the provisions of article 360 clause 4 of the Constitution, it says the salary of the judge of the Supreme Court and the High Court as fixed by the Constitutions cannot be varied or reduced by the Parliament except during the period of financial emergency, when the President may by order reduce the salary of the judge of the Supreme Court. So, as far as this provision is concerned, it is only in case of the financial emergency if the President decide to proclaim under article 360 of the Constitution, then only in such contingency the salary of the judges of the Supreme Court and High Court may be varied or reduced. But so far this provision is never being invoked by the judiciary, and other thing is that their pensions, allowance and other privilege cannot be varied to disadvantage. So, this kind of the provision has been provided to ensure the independence of judiciary. And apart from this, you also have the provisions like article 126 of the Constitution which provide for the appointment of the acting Chief Justice, and what has been prescribed that when the office of Chief Justice of India is vacant, or when the Chief Justice is by reason of his absence or otherwise is unable to perform the duties of his office, then the duty of office shall be performed by such one of the other judge of the court as the President may appoint for this purpose. So, as far the acting Chief Justice of India is concerned, it may be appointed if in the absence of the Chief Justice of India. I think the time will not permit.
I think that time is not permitting us, but I would like to tell you all that Dr. Rakesh Kumar would be again with us tomorrow, and we would be continuing further as well as we would be learning something new through him. So, thank you Dr. Kumar, thank you so very much for being the part of the EduSet lecture.